Good evening. We are starting the final session of the 7th International Forum for Competition. You are all kindly invited to take your seats. We are really behind the schedule, so I kindly asked all of our speakers to be as concise as they can, so to concentrate on the key problems, key wishes to MCU, what maybe European partners would like to wish to the committee. I'm happy to see here not only the employees of MCU, but also I can see some representatives of partner public authorities, civil society, lawyers. Today our department received many telephone calls and they asked questions. How come you made this a state aid session the last one? And the answer was that it's like a star who takes the last presentation, on stage. So we thought we'll discuss the most interesting points. We already can share some specific examples of application of the law. So it's not only about obligations, international obligations, legal provisions. We can tell about some starting practical points. Today we discussed a number of reform aspects. And of course the matters related to state aid reform has to become an inseparable part of the protection of the competition, because it's not about the Ukrainian international obligations. It's about the transparency, because no public authority would be able to answer the question on how much they spend to support different kinds of businesses. It's about competition neutrality, it's about favorable competitive environment, prevention of any distortion of the competition, and as a consequence building up effective system of financial management in the country. So Oksana is our first speaker. She is the acting department director. Tell us about your key achievements, and maybe you should also focus on some key aspects which we are working upon and which are important, as well as future steps. Can I kindly ask to put my presentation on the screen? So, I would like to suggest your attention the most relevant subject matter, which is about the state aid to business entities. What do we have? We have the effective law of Ukrainian state aid. These are amendments to the budget code concerning regulation of the state authority for state aid, public authority for state aid. We have the procedure to submit information or reports about the state aid to the Antimonopoly Committee, and our major achievement is the adopted criteria for assessing admissibility of competition in Ukraine. That's a matter for professional training, for development and support of small and medium-sized businesses. Of course, that's important subject matter for scientific research. So why do we need these criteria? First of all, we need them to regulate the legal field between the Anti-Monopoly Committee and providers. Of course, the aim is to reduce negative impact over the competition, because these criteria will help at the first stages in putting together the state aid programs, so that all relevant aspects can be taken into account, namely the aspects of minimal influence or impact over the competition. To give you an example, that's the slide. This is, as you can see, long-lasting process of approval of such criteria. The relevant working group was established in 2000 16 we have final results. Final result now, January 2018. We have ready for use criteria that can be applied. By some reasons I cannot switch the slides, so as of today we have the Department for State Aid composed of 17 members who are providing consultations, advice to the representatives of public authorities. They have conducted about 120 activities, received a lot of telephone calls. The AMC already received 24 formal reports. Certainly we had to comment on them. 16 of them we accepted for review. Some others were sent back for putting them in compliance with the legal requirements. Out of 16 reports that are under review now, we already have 2 decisions made concerning the healthcare institutions belonging to Kyiv City Council and also the Odessa Transportation Company, where we clearly demonstrate that the state support measures do not constitute the state aid as such. For your attention again, this specific decision concerning the city transport companies. We say that if there is justified compensation of the cost, then this is just an issue of general economic interest. Also, we worked with the Ministry of Energy. We implemented monitoring of all existing schemes and procedures of state aid, where 12 programs were identified which contain signs of state aid. Now we are working together with the energy community to develop the relevant programs on the basis of European legislation. Also, talking about achievements, we received a complaint from the company New Post Office concerning the reduced lease rate for one of the premises they are leasing. We already had consultations with the stakeholders, interested persons who share this information. For today, many requests have been sent, requests for information, so that we can analyze the situation and make decision. Well, based on preliminary analysis, I can tell you that this measure indeed can have signs of the effective state aid. We actually provide a lot of different explanations. We issue them, publish them to avoid situations with the state aid. We explain the situations for the local self-government, local councils. We also explain provisions of which exempt the agricultural companies from compliance with some of the provisions of the law. And of course we have some achievements. We've been working already for almost half a year. We certainly want to understand the future, so we are planning in advance what we intend to do in the future. First, we certainly need to ensure amendments to the law of Ukraine on state aid to the business entities. Another important stage is they need to amend the tax and customs code to bring them in compliance with the law of Ukraine on state aid. The relevant working group has already been established. They had their first session when we agreed on the basic lines of our activity for the beginning. So it consists of representatives of Ministry of Finance, State Fiscal Service, and representatives of Custom Authority. Of course, we also need to develop criteria to assess the admissibility of measures to protect the environment. That's a number of special criteria. Also, we need to issue the explanations of why such measures are needed, so that the providers can have an understanding of when they do not need to really send any reports to the AMCU. We do not want to interfere with operations of any of the ministries. We just what we need trying to do is to really control the impact over the competition. So we certainly need to provide better interpretation of what is meant by public economic interest. Also, we need to deal with support provided to international financial organizations and also support to the natural monopolies. So our key points is that we need to explain the situations when a company does not need to make any reports to the committee and doesn't need any interference from the committee. Talking about some difficulties and complications in the work based on the law of state aid, certainly there are some aspects which are very serious. First of all, we need to really amend the law on concerning the trade with the impact of the state aid over the trade with the European Union. Such enterprises should not need to submit such reports to the committee. We need to provide for a new definition to define an exclusive economic activity by a business entity. That will also reduce the load over the socially oriented organizations like schools, hospitals, would not need to make any reports to the committee. Definition of criteria for compensation, paying compensation in case of absence of state aid, and also we need to improve the procedure of submittal of information about the existing and the new state aid procedures or schemes. I'd like to say that this law is used very actively in practice. We already have achievements. I can say that 17 employees of our department are working hard to explain, to really give a good idea about these aspects, and hopefully we'll be able to minimize the necessary cost and to generate this kind of state aid to only those who really need it. Thank you for your attention. Thank you, Oksana. I think it was really difficult to tell about the work of your department within 10 or 12 minutes. Now I want to invite to the floor our, I would say, friend and partner to the Department for State Aid. We've been contacting this person all the time, had a number of meetings. This is Jose-Manuel Hernandez, the first secretary of Representative Office of EU in Ukraine, who used to work at the General Directorate for Competition Matters, dealing with matters of state aid and energy sector. And also we should keep in mind that one of the key priorities within the state aid system, we always focus at the energy sector, and of course the expert support provided to us and certain guiding to guide us to the path towards European integration. So, Jose, please, the floor is yours. Please, could you shortly comment on what we managed to do? What are your wishes for the next period, and what are your expectations concerning the entire?
Many thanks, Anna, for this introduction. Actually, being qualified as a friend is actually quite an honor. I think it's the first time in an event that I don't say good morning or good afternoon, but good evening. I am actually impressed to see that there's still people holding here. I would like to be quick, and I would like to actually focus on 3 things today. The first one is to remind everyone a little bit of which are the key milestones that we have in the association agreement. The second one is to give you a preliminary assessment of how state aid control in Ukraine stands against the association agreement. And the third bit I want to discuss with you is our preliminary views on the way forward. So in this slide, actually, we can see 4 key dates. This is the end of this year, the end of 2019, the end of 2020, and the end of 2022. Because of the lack of time, I'm not going to go through each of these boxes as I plan to. I'm only actually going to go through the first two boxes. So that means end of 2019, the deadlines we had, it was to establish a state aid control body in Ukraine and to establish state aid rules. In the second box, we actually had for the end of next year that the control of new aid should actually start. As these are the 3 bits where already Ukraine has moved forward, I will move now to the next slide to start making a bit of a qualification of where do we stand. Why do we have these colors? So for the blue, it's actually something that has been achieved. Yellow is where we actually have some partial degree of achievement, and red is where actually work still needs to be done. So we actually move to the first slide, and we can see the first box is quite easy. Ukraine has already established a state aid control body, which is the Antimonopoly Committee. Now a more tricky box. It's actually adopting state aid rules. This is not a very straightforward thing to just see which rules actually constitute properly EU state aid rules, as we do have about 1,000 pages at the very least of state aid legislation in the EU, so it's a bit of a difficult qualification. But here is our first attempt. What we do consider is that a 2014 law, it is really a good starting point for enforcing state aid control in Ukraine. The next positive thing is that most procedural rules are already in place. This also includes the procedures for recovering state aid recovery, which has been deemed as illegal and incompatible. The next bit, when it comes to the adoption of state aid rules, is that we already have 4 resolutions on compatibility rules. Now we go into the bits which are still actually unchecked. The first one is actually about divergent concepts that we see in the law as against the association agreement, which means EU state aid law, is the notion of aid. So here there are 3 concepts that Ukraine can certainly already start assessing, but we feel that AMCU Ukraine can actually not really profit as much as they could from the whole body of case practice and case law, and it could just take Ukraine through a divergent path. Here we are referring to the definition of state resources. We are the impact on trade, which actually Oksana already mentioned, and the third bit actually is on the definition of undertakings, which for under EU law is simply the concept of economic activity. We feel the current definition will take Ukraine through another path. The other is about exclusions. So the law excludes, for instance, services of general economic interest. Under EU state aid law, services of general economic interest, they can be brought forward, but they must be compatible. So bottom line is that it should not be an outmost exclusion, but just an assessment of compatibility of those services of general economic interest. The last 2 bullet points are actually about the architecture of compatibility, and about probably one of the most important elements is the assessment of state aid under the law. I will leave these 2 points for the next 2 slides. Now we move into the box on the control of new aid. So the deadline under the association agreement would be end of next year, but Ukraine already kicked this in on the 2nd of August of last year. Now on the positive is that an obligation to notify was indeed put into effect. We also see that the law, even though there are divergent elements, at least allows AMCU to assess whether a measure constitutes or not aid. The next good thing is that there's been already some decisions on no aid. There's been an incredible number of notifications and a very high engagement between the Antimonopoly Committee and shareholders. So this, I think, is actually very good. Now, on the bits which are not so good, the obligation to notify was introduced without having passed compatibility criteria. This means that state control was largely non-operational, other than assessing whether or not aid was in or not. Now we have also seen that granting bodies were notifying, but they were not always waiting for clearance from the Antimonopoly Committee. And this is the breach of one of the very same principles of state aid, which is the standstill clause, is you must wait for clearance before actually passing an aid measure. We also do see potentially a bypass of a state control when laws are initiated and promoted by MPs. And here, in the EU, it's not always so common that you will find stated measures defined in the law, but here we've seen some examples that it is the case. And therefore, we think that that loop should actually just be closed down. And now I will want to revisit those points I was referring before about the architecture. This slide is not an assessment, it's actually how the architecture of compatibility looks in the EU. And I would like to start from the very upper part, where it does say assessments directly under the treaty. This is the way normally any state control system may actually need to start. You don't have experience, and therefore you start with very general compatibility criteria and running your cases directly against those criteria. When you actually start gaining some experience, you go for guidelines, which in the EU, no one has really counted them exactly, but it could be in the range of 40 to 50 in a myriad of horizontal and sector-specific. When you have even more experience, you develop block exemptions, which means there's no need to notify. It is considered that if you meet those requirements, it is automatically compatible. And in 2016, about 80% of the cases were already block exempted. More than 90% of all aid was actually granted through these block exemptions. And the downer box is about the minimis, which is very low amount. In the EU, 200,000 over 3 years for one undertaking is considered not to distort competition and therefore exempted. Now we see the architecture we have in Ukraine. So we've got on the lower part the minimis, which is good, maybe need to be revisited, but at least it allows for those small measures not to be caught by state control. Then we've got 4 guidelines, but the worrying bit is everything else, because currently there are no powers to the state control body to assess measures directly under the law. So there is one possible interpretation. The law says that state aid in principle is not allowed unless you have compatibility criteria. So if you have no compatibility criteria and the anti-monopoly cannot actually assess any measure under the law, they could very well conclude that that measure should be forbidden. The impact that that could have is just simply phenomenal. So here our biggest suggestion here is to enable, let that be under the law or whatever the mechanism for AMCU to assess compatibility directly under the law when there are no specific rules developed. And now I will quickly move a bit into the way forward. So the first bit is actually on the legal framework. Sort of recapping up, the first bit is aligning those elements that we have actually listed in the first slides. with the association agreement. The other one is to continue developing that state aid compatibility architecture. And here we're actually not calling to mimic the same architecture as in the EU, just have some rationale into what works better. For instance, block exemption maybe is not now needed, but certainly that power of AMCU to assess directly under the law, it should be enacted as soon as possible. And the last bit is, again, this copy-pasting on guidelines, it just does not work. Every guideline has been actually developed looking the market conditions in the EU. So therefore, the Anti-Monopoly Committee with granting bodies need to develop sensible rules that can work. Next important bit is actually starting to build up an enforcement record. We have heard already that there's been a couple of decisions on no wait, but the most important ones will be actually once you start moving into compatibility decisions. Linked to that is actually about communication and advocacy. We know that state aid is not actually a very friendly instrument, notably towards state granting bodies. So it will actually be quite important to package maybe the first decisions into one package and certainly explain those benefits to granting bodies and the public at large. The last slide actually is showing the second bit of the way forward. We are all looking forward to the first report on state aid, as we are all now commenting, of course, on the feelings that we hear and hear, but we feel that we just need some data and some analysis on what has happened since August 2017 until ideally maybe mid-2018. Standstill clause, I mentioned that before. It has to be taken quite seriously by granting bodies not to pass measures before getting the formal clearance. SOEs, we do feel it is a big thing in Ukraine. We know a lot of the aid actually may go to state-owned enterprises. We do not have an issue when the SOE is actually undertaking any public service obligation. The main thing is when the SOE is actually conducting an economic activity and offering services to the market. And here, actually, what we feel is that granting bodies need to start thinking as what we call a market investor. They need to start thinking, whenever they think of a capital injection, into what would a private investor do. Otherwise, all those measures will certainly be found as first an economic advantage, and depending on that measure, potentially incompatible if they distort competition. The last bit, and not the least, is existing aid. Here is where we have the most time for aligning state aid with the association agreement. So it's altogether 7 years since 2016. However, it is a daunting task. It's a daunting task if one looks, for instance, at aid to coal. You do need a lot of years. So ideally, you need to start thinking now into what do you have and how do you want to move from today into a measure which is actually compliant with EU state aid rules. And I think I will leave it there. Thank you.
Thanks a lot, Jose. Unfortunately, we do not have time for comments, so I have to present next speaker. It will be Marie-Therese Richter. Short introduction in Ukrainian. Marie-Therese Richter, вона є юристом із Секретаріату енергетичного співтовариства і
community. So, looking at how long I know her and we are acquainted, I guess I know her active position, and she's already the friend of Antimonopoly Committee. She's the person who will be always to respond quickly any questions about the state aid in the energy sphere. So it's really pleasant to see you. This is not the first forum with the participants of Marie-Therese, and we are expecting for a very short presentation about what for today we were able to accomplish and what wishes do you have for the future. Thank you.
Does it work? Now it works, right? Thank you so much for the introduction. Thank you for the invitation. It's a great pleasure to always be here. I will be very short, also thanks to Jose-Manuel, because there would be something wrong if we had diverging views on this, where we stand and where we should be going. So I can just put a focus on a few things that I would like to say, where we see the most promising steps that have been taken, and where do we see that it is going or where it should be going. just in one sentence, why do we say where we see the AMCU going and the state aid enforcement system going? The energy community is a sectoral international organization building upon the same rules as the EU, but sector specific in the energy sector. So we speak for this one sector, but it is the same like in all sectors. Ukraine is a member of this organization since 2010. I think it signed in 2011. It came into force. And one of the obligations in this sectoral organization is implementation of competition and state aid prohibition. And this is why we have an opinion on where state aid and competition should be going. This I will swap. This is the same like in the EU, only focusing on energy. What does this mean? Under the Energy Community Treaty, you therefore have an obligation for our contracting parties to transpose. And there we have a rising sun. As has been mentioned, transposition finally happened. Took quite a while. This is why we also had some issues in our dispute resolution cases. However, I think there are a few issues that Jose-Manuel has already mentioned. I would just like to add probably the middle one, where in the energy sector we're a bit concerned because infrastructure, there is an exclusion that we think it should be very important to mention that energy infrastructure also needs to comply with a state aid criteria. So sunny sky with a few clouds, I would say. And the other obligation is implementation. Obviously, there has been no implementation as long as there was no law. But now that it has entered into force, I have to say chapeau for the AMCU, which actually starts right before actually entry into force to implement this law. Obviously, there are some hurdles to take, but I'm very happy to see that the sun is rising. And particularly in the energy sector, I think there's a lot of activity going on, and it's really, you have to start somewhere, and it's going to be the same for all the sectors. I would like to mention a few positive developments that we were involved and that we think are very important and brought great steps forward. The pilot project, which basically was before the entry into force of the law, they started assessing already a high number of potential state aid measures in the energy sector, starting not only with listing them, but analyzing them. So a great exercise to take stock of the measures on the market and also to start assessing them. Second, we've already heard from both sides the drafting of compatibility criteria, actually, I should say. Very important. Of course, you could assess state aid also just based on the basic provision of compatibility. However, what we are facing very often are requests from investors. So we have a strong interest that investors feel comfortable going to Ukraine. And this is when you have transparency, when you know what to expect from the enforcement authorities. And this is exactly what those criteria will aim at, to show how enforcement practice, for example, in environmental aid and also covering the energy sector, will work. And finally, very promising is the number of notifications that has been mentioned. You wouldn't be anything without any notifications. You have to have the cooperation of other authorities. This has been mentioned in the first panel, and I think this closes the circle a little bit, that you don't act in a vacuum. You're an enforcement authority. You're not responsible for everything. You're the enforcement authority and therefore have to rely on notifications. So what would I wouldn't say, where do I see you in 10 years? Because obviously I would have to say that there is a perfectly working enforcement system, that I will never have to come to Ukraine again, which is not true. So I think it's much more useful to say what I think will take you there in the next 10 years. I think, going back to no vacuum, it needs a change of attitude. I have the feeling that many state aid grantors think that state aid is bad. I have to try to get out of state aid at all. No, it can be compatible state aid. This is not a problem. You need to understand what state aid is. Either it's pretending or it's really like that many public authorities don't know what it is, when they need to notify. So it's your task to distribute the knowledge, to get people to understand what it is, but it's the others' duty to notify this to you in the process. Very important, and we faced this, we discussed this yesterday, is the question who needs to notify. There should, of course, not be a loophole for MPs to bring a law, not to have to notify. So change of procedures, awareness raising, and the willingness to actually apply the system. I think in those next 10 years, EMCO is going to establish an assessment practice that deserves this name, because after half a year, you already started with it. You're very strong, and this conference is also assigned for this, in consulting with stakeholders. And of course, the final note, of course, I will always continue to reply fast to your emails. Thank you.
Thanks, Marie-Therese. У нас вже останній speaker.
Having the last speaker left before the dinner, this is Iaroslav Gregirchak, the Deputy of the Business Ombudsman of Ukraine. Iaroslav, would you please tell us, you as an institution which needs to protect the rights of the business, did you get any complaints for the authorized body of the state aid, or you will get those complaints later on? Thank you, Anna. I do understand. As I am the last speaker at this conference, I have a duty. As for the expectations the audience is having, not only about the quality of the content or the sense of what I'm going to tell, but about the time I will spend for that. I will try to meet your expectations. So answering your questions, no, we didn't have any complaints. Well, coming beyond the topic of this panel discussion, as for state aid as the privilege which mainly this last speaker like I am can have, in more details I will tell you how the statistic looks like about those 24 complaints which came not according to the topic of the state aid, but at all from the business entities of the National Competition Agency. I've already mentioned in the morning that since May 2015 until now we've got only 24 complaints, which is a totally marginal figure, taking into consideration that an overall number of complaints is more than 3,600. And this is knowing the fiscal topic. This is approximately 45% on fiscal topic. For law enforcement, this is approximately 15%. Local self-governance authorities, 12%. In this case, the percentage which deals AMCU and regional departments, territorial departments, is really not that big. Partly we can connect it to the situation that some public procurement is really efficiently working mechanism of complaints. And where we have it efficient work, we see fewer complaints, not only about AMCU, but about the Ministry of Justice too. Because as for this topic and complaints of the state registrators, we don't get that many complaints either. So out of those 24, and it's apparent that taking into account that a part of the audience are the workers of the AMCU, it would be interesting for you to get to know, out of those 24, we didn't take 12 of them at all, knowing the overall statistics. That approximately 1/3 is not taken for the procession if we look at our all activities. In case of AMCU, we didn't take the half, well, they were not substantiated. I can answer you. In 2 cases, those circumstances were already at the court, and according to our regulations we can't take those complaints under the processing. In the 4 cases, we didn't have the proper formulated evidence, so the argumentation was about the unfair behavior, but we didn't get the proper proof evidence base. And in 6 cases we qualified the lack or the absence of the unfair behavior. For instance, we came to the conclusion, in one of the cases, that the decision of AMCU is final because of the Article 58 of the law on the economic competition, or there was no unfair behavior when AMCU was making a request on the information, and in one case it was a voluntary polling, so there was a complaint on the voluntary polling as it is. Of course, we didn't process it. So out of the 12 which were left, we are having 5 cases which can be considered to be successfully solved for the complainant, but we needed to explain the sense in these complaints. There were cases when the complaint was satisfied and our recommendation was to begin the trial as for the violation of the law about the protection of the economic competition. There was a very interesting case when one of the territorial departments, for 3 or 4 years running, they were requesting the same information from our complainant. He was always giving it, but then he was tired of that. Well, of course, this was the implementation of the discretion which was excessive, so we stopped this practice. There was one case which we qualified as a successful one, when we took into consideration the additional information of the complainant, because we could do that according to the Article 58. So we took the formal decision that it was the successful finalizing of the case, though the final verdict was similar to the primary one. There are 6 cases when we qualified in the context of this sphere that the complaint was not satisfied. We just stopped it because of the absence of the result which the complainant was figuring about. In some of the cases there were approximately at least 2 of them when we recommended AMCU to drive their attention into our understanding. In the context of the first session, you should said that this was a procedural integrity and fairness and fair implementation of AMCU of their discretion authorities as for the assessment of the circumstances. Because in those cases where I took part, as for the procedural fairness, everything was just perfect. But AMCU decided to implement their discretion in the different way. And those are the circumstances where our mandate is over. We don't have the certain authorities. We value an opportunity to express our opinion at the platform of AMCU, so we're giving certain recommendations. One more case was when the Council recommended AMCU to implement their discretion and to look at the delay of the penalty payment. And it was done formally, trying to listen to the opinion of the complainant. And we didn't achieve the result. This is the typology. There was one recommendation which can't be comparable to the 800 of the recommendations which we gave at the level of the individual investigations. And still, it's not that involved into the AMCU activities. It happened because of the lack of the sectoral regulator in the transport sphere, which could form their sectoral list of the natural monopolists and to give this list to the AMCU, which then, as a result, would introduce this data into the overall list. We are sure that we are having the situation when it's apparent that a transport regulator in the sphere will be formed finally, and this recommendation will be accomplished. Iaroslav, would you please finalize, because I think they will turn off the light now. Okay, then, this is our success story as for the systematic recommendations. We've got 28 recommendations, all of the 5 as for the criteria of the accessibility according to 2 topics and the thing of methodology of calculation of the state aid are in fact accomplished. I'm really glad to tell you about that. And as for the rest of the recommendations, we do support 6724 and 6746 in the part of the institutional capability and the responsibility, the first steps of the separation of the decisions between the investigations and the terms at the legislation level. We are totally ready to support you in that. Thank you. Thank you so much, Iaroslav. Thanks to all of the speakers here. Unfortunately, we don't have any time left for the Q&A session. So I offer, if you've got, out of the audience, you've got any questions, please take it to the dinner part, because we are totally short of time. So, Yuri Alexandrovich, maybe the final speech from you to wrap up with the forum. Dear colleagues, first of all, I am apologizing for taking 1 extra hour of yours here, but simultaneously I'm really grateful for you that in spite of such a late hour for the forums, because forums are mostly finalized at 5:30, right? Still, there are lots of you here. It's really nice that every year our forum, out of the discussion of some theoretical questions and issues and some of the wishes how nice it would be for us to develop something, it has become finally the problematics platform, which is becoming more precise and exact, and sometimes we have broader issues discussed, open discussion issues, which we began with. They still have the level of professionalism of the discussion of those issues, and the level of the professionalism from the committee side and from all of the participants of the discussions is rising from year to year, approximately for 50% every year. Of course, it witnesses that in Ukraine there's formed a very strong law culture, law economic culture, and understanding of the issues, what the competition is, what the competitive environment is, which is not a politicized, primitive one, but is really the proper one, an appropriate one, how it should exist in the modern European state, which has the priority of the implementation of economic policy and formation of the implementation of economic policy according to the best world standards. It wouldn't be possible to implement if we were not the part of such a civilized world. If we would be isolated without having an opportunity to communicate with our partners, world partners. And since the moment of the formation of the new board of the committee, since 2015, since the very beginning, we are feeling such a very frank and honest, sincere support and the wish to share with us the best accomplishments, to answer our requests, to give us the information and data as for the cases, to give us advice as for the precise questions and implementation of new laws. We really value all of that. So again, I'd like to personally thank all of our international foreign guests who took our invitations and came to this forum. And undoubtedly, I'd like to thank separately the people whose logos are in the left corner of this banner, of this placard. Those are the people. Well, reality is reality. Good intentions are good intentions, but still sometimes you need to have some practical support in the organization of the event. So that is why without the support which we got both from our partners, if I'm not mistaken, from United USAID and the Swiss Agency of International Development, the World Bank Group, the informational support from ACC, EBA and the Federation of Employers of Ukraine, and the support from the Interfractional organization. I'm really grateful for this support too. I think that without that we wouldn't be able to cope with the organization of today's meeting. And again, this forum, well, I think you witnessed, and I don't need to repeat, that this forum is not the show business. Those are not speeches for the sake of the very best and against everything evil. This is a very working process, when we want to see the solutions and decisions made, and we will get it. That is why, again, I'm really grateful for you, for the participants. I'm glad for your interest. I'm grateful for your support. So maybe now this official part is a bit too long. It's a bit too long. So let's finalize it and let's come closer to the wine glasses. And the people who are already sleepy enough, you can go to bed. Who wants to go on with communication, we can go on with communication too. Thank you.